Justice Alito, with whom Justice Thomas joins, concurring. I join the opinion of the court, but write separately to note two related issues that are left unresolved and potentially threat the practical significance of today's decision: the availability of third-party standing and class certification. First, the court does not address the weighty issue whether the state plaintiffs have third-party standing to assert the citizenship clause claims of their individual residents. The government's applications to partially stay the preliminary injunctions are granted, but only to the extent that the injunctions are broader than necessary to provide complete relief to each plaintiff with standing to sue. Ordinarily, a litigant must assert his or her own legal rights and interests, and cannot rest a claim to relief on the legal rights or interests of third parties. Powers v. Ohio, 1991. In limited circumstances, however, the court has permitted a party to assert the rights of a third party. Admittedly, the court has not pinned down the precise circumstances in which third-party standing is permissible. See Lexmark International, Incorporated. v. Static Control Components, Incorporated, 2014. And commentators have emphasized the need for greater doctrinal coherence. But at a minimum, we have said that a litigant seeking to assert the legal rights or interests of others must demonstrate ordinary Article III standing for itself, and answer the additional threshold question whether it has standing to raise the rights of others. Kowalski v. Tesmer, 2004. But CFDA v. Alliance for Hippocratic Medicine, 2024. Thomas J. concurring. This latter requirement, as we have explained, entails a showing that the litigant has a close relationship to the right holder, and that there is some hindrance to the right holder's ability to protect his own interests. Kowalski, quoting Powers. So long as third-party standing doctrine remains good law, federal courts should take care to apply these limitations conscientiously, including against state plaintiffs. That is especially so in cases such as these, in which the parties claiming third-party standing, i.e., the states, are not directly subject to the challenged policy in the relevant respect and face, at most, collateral injuries. Today's decision only underscores the need for rigorous and even-handed enforcement of third-party standing limitations. The court holds today that injunctive relief should generally extend only to the suing plaintiff. That will have the salutary effect of bringing an end to the practice of runaway universal injunctions, but it leaves other questions unanswered. Perhaps most important, when a state brings a suit to vindicate the rights of individual residents, and then procures injunctive relief, does the injunction bind the defendant with respect to all residents of that state? If so, states will have every incentive to bring third-party suits on behalf of their residents to obtain a broader scope of equitable relief than any individual resident could procure in his own suit. Left unchecked, the practice of reflexive state third-party standing will undermine today's decision as a practical matter. Second, today's decision will have very little value if district courts award relief to broadly defined classes without following Rule 23's procedural protections for class certification. The class action is a powerful tool, and we have accordingly held that class certification is proper only if the trial court is satisfied, after a rigorous analysis, that the prerequisites of Rule 23a have been satisfied. Walmart Stores, Inc. v. Dukes, 2011. Internal quotation marks omitted. These requirements are more than a mere pleading standard and a hasty application of Rule 23 of the Federal Rules of Civil Procedure can have drastic consequences, creating potential unfairness for absent class members and confusion and pressure to settle for defendants. General Telephone Co. of Southwest v. Falcon, 1982. Recognizing these effects, Congress took the exceptional step of authorizing interlocutory review of class certification. See Federal Rules of Civil Procedure Section 23. F. Putting the kibosh on universal injunctions does nothing to disrupt Rule 23's requirements. Of course, Rule 23 may permit the certification of nationwide classes in some discrete scenarios, but district courts should not view today's decision as an invitation to certify nationwide classes without scrupulous adherence to the rigors of Rule 23. Otherwise, the universal injunction will return from the grave under the guise of nationwide class relief, and today's decision will be of little more than minor academic interest. Lax enforcement of the requirements for third-party standing and class certification would create a potentially significant loophole to today's decision. Federal courts should thus be vigilant against such potential abuses of these tools. I do not understand the court's decision to reflect any disagreement with these concerns, so I join its decision in full.